Good morning. Today the court will hear the case of Sophia's parents v. Hong Kong government. Earlier this year, the plaintiff lost their 6-year-old daughter, Sophia, to acute asthma attack. Sophia suffered from breathing problems and asthma symptoms throughout her life. On the day of her death, Sophia had dried apricots that were purchased during the family's recent trip to Thailand. The dried apricots contain sulfur dioxide. The products were produced in Hong Kong and then exported to Thailand. 6 hours later, Sophia died. Now the plaintiff, Sophia's parents, is suing the Hong Kong government for indirectly causing their daughter's death. The plaintiff is represented by Mr. Lim, defendant by Mr. Wallerstedt. Let's hear from the plaintiff first.
Your Honor, I wish to sue the defendant, the Hong Kong SAR government, for its 3 negligence of duty of care, which indirectly caused the death of my client's daughter, Sophia. Firstly, the government did not prohibit the usage of harmful preservatives such as sulfur dioxide on food. Secondly, the government is negligent in food regulation, whereby it did not necessitate the labeling of harmful preservative on sulfur dioxide on food, especially for the purpose of exporting. Thirdly, the government failed in regulating, monitoring, and countering the severe Hong Kong pollution issue, whereby concentrated sulfur dioxide has inflicted long-term detrimental health effects on Sophia.
On behalf of the Hong Kong government, I state that we are not guilty on all 3 of the accusations.
Firstly, allow me to present my case for the accusation of government's breach of duty of not prohibiting the usage of sulfur dioxide preservative. It has been asserted by the basic law that the government has a legal duty to guarantee the right of life of all residents. This implied that the government should do their best to protect its residents from harm. Based on the current law under the Preservative in Food Regulation of the Public Health and Municipal Services Ordinance, Caption 132 had banned the use of sulfur dioxide on fresh meat. Hence, it is known that the government is well informed of the potential life threat of sulfur dioxide to sensitive asthma patients. However, the government did not prohibit such usage to vegetables and fruits, which in my client's case has indirectly caused the death of Sophia. Moreover, according to the science literature from US FDA or Food and Drug Administration Authority, 10 milligrams per liter of sulfites ingested in one sitting could pose a life-threatening hazard to a sulfite-sensitive patient. Outrageously, that under the Law of Preservative of Food Regulation, Chapter 132 BD, Schedule 1, the Hong Kong government permits maximum usage of 2,000 parts per million of sulfur dioxide preservative, which is equivalent to 1,997 milligrams per liter. This has imposed over 200 times more life-threatening risk to a sulfite-sensitive individual. Meanwhile, let's compare the practice of Hong Kong government, an advanced country, to that of US regarding the matter. The US FDA has prohibited any usage of sulfur dioxide in meat, vegetables, and fruit since 1986, with the well-publicized Celebra death case of at least 12 asthmatics since 70s and 80s. As a result, if the government had prohibited the use of sulfur dioxide preservative, the dried fruit apricot would not have been produced in the first place and would not have been purchased by Sophia's parents, which causes Sophia's death.
What do you have to respond, defendant?
I would like to explain Hong Kong's remoteness to the purchase of the dried apricots. They were purchased in Thailand. It is their jurisdiction and responsibility to monitor all the imports to their country. We have not breached our duty of care. In fact, we have already banned the use of sulfur dioxide in all meats in Hong Kong. The parents are guilty of contributory negligence. They have known of their daughter's condition of severe asthma for years. The parents should not have allowed Sophia to consume the dried apricots, which are known to contain sulfur dioxide. Sulfur dioxide is widely known as an irritant to those who suffer from asthma, and it is known to set off asthma attacks. Additionally, it was negligent of Sophia's parents to not instruct Sophia to carry her inhaler with her at all times. It is known that inhalers are the best defense against asthma attacks, which can lead to death.
Do you have anything to add, the plaintiff?
Secondly, allow me to put forward my case for the accusation of government's breach of duty of not necessitate the labeling of harmful preservative sulfur dioxide on food, especially for the purpose of exporting. Under the current law of preservative in food regulation, Chapter 132 BD, Section 6 and 7, the government requires the labeling of food containing preservative for local production, but Section 7 revokes such law to be not effective if import is solely for the purpose of re-export or goods manufacturing in Hong Kong is solely for the purpose of export. Such law is not reasonable, as developed countries such as the United States, European Union, and Australia has made compulsory the labeling of sulfur dioxide on all food. Without the presence of sulfur dioxide, Sophia parents were not able to know of all the ingredients applied in the dried apricot fruit and whether or not it is sulfite-free. Hence, the absence of labeling has indirectly caused the death of Sophia.
And what do you have to respond this time, the defendant?
Hong Kong labeling laws demand domestic products containing sulfur dioxide displayed on the packaging. Due to remoteness, Hong Kong should not be responsible for labeling products that will not be bought within our country. The Thai government is guilty of contributory negligence. They should have the duty to inspect all imported goods. In the United States, all imported goods that do not have labels can be instantly forfeited. The reasonability test would suggest that Thailand should hold some responsibility for not having similar policies. Due to the degree of separation of the apricots being produced in Hong Kong, exported to Thailand, then bought by an asthmatic there, brought back to Hong Kong, being eaten in Hong Kong, and then having Sophia suffer from an asthma attack, has created a small sense of foreseeability in the issue. And again, it is critical to mention that Sophia's parents exercised contributory negligence as they knew of Sophia's condition, yet they carelessly allowed Sophia to eat the dried apricots and did not have an inhaler on hand to protect her from an asthma attack.
And the plaintiff, what are your other accusations?
Thirdly, I wish to present my case for the accusation of government breach of duty for not effectively regulating, monitoring, and countering the severe air pollution issue in Hong Kong. According to data of US, sulfur dioxide is known as a potent asthma trigger and can cause other respiratory health effects. Children are generally more vulnerable to effects of sulfur dioxide than adults. According to Sophia parents, the severe Hong Kong pollution is suspected to cause long-term health effects on her. Their trip to Phuket, Thailand have further confirmed their suspicion. The air was clear in Phuket, and Sophia told that she had never breathed so effortlessly in her life. If the Hong Kong government had taken more effective measures to tackle air pollution, Sophia wouldn't have suffered from asthma in the first place. The government negligence is evident. In June 1995, instead of adopting internationally accepted benchmark index for pollution, the Environmental Protection Department set up its own air pollution index as an indicator to pollution level. To make the matter worse, the air quality objectives that were established in 1987 under the Air Pollution Control Ordinance have not been reviewed for 20 years since it was established. In recent years, the street-level air quality falls short of the government air quality objectives and even further short of World Health Organization air quality guideline. In comparison, developed countries such as the United States managed to reduce air pollution by 31% from year 1981 to 2000 under the US Environmental Protection Agency Acid Rain Program.
What do you have to respond, defendant?
The plaintiff has failed to show causation from the pollution as the cause of Sophia's death. While it may have affected Sophia's condition, the apricot was ultimately the cause of death. Our medical research has shown that there's a high possibility that Sophia's asthma was actually developed by a hereditary condition and not simply because of the pollution in Hong Kong. The Hong Kong government has not breached its duty of care. Much has been done over the past decades to fulfill this duty. The Air Pollution Control Ordinance has been working to improve the quality of air in Hong Kong for years. Pollution from Guangdong has been flowing into Hong Kong. There is little that we can do to restrict this. In fact, in the case of Clean Air Foundation versus another government of HKSAR, the judge found that Hong Kong was innocent for their policies to reduce air pollution in Hong Kong. This precedent should show that Hong Kong's efforts to clear out the pollution in the air have done much to meet their duty of care. Again, I must stress that with the parents' knowledge that Sophia does not respond well to the Hong Kong air, that they are negligent for not being on hand or at least having her carry her inhaler with her at all times to protect her against an asthma attack.
The court has heard from both sides, and the judgment is as follows. First, the court finds the Hong Kong government breaching the duty of care by not prohibiting the overuse of sulfur dioxide in all food. The government fails to pass the reasonability test, which requires the authority to match its food additive regulations with those of other advanced economies. Had the government done so, the high-level sulfur dioxide dried apricots would not have been produced and would certainly not cause Sophia's death. Second, the proximity relation that Hong Kong government has indirectly caused Sophia's death might be too weak to constitute a breach of duty of care. The Hong Kong government simply cannot foresee the string of events, that is to say, products produced in Hong Kong, exported to Thailand, not inspected by the local authority, and then bought by Sophia, who suffered from asthma attack, causing her death. Third, the court does not find direct linkage between Hong Kong government's handling of the city's air quality and Sophia's death. Sophia did not die from breathing bad air. She died from consuming food that contains sulfur dioxide. The court now rules that the Hong Kong government should pay damages to Sophia's parents.